person is or were in a close relationship with the abuser, or shares or shared the same residence. Now, when we start looking at these concepts of what a domestic relationship is, there are terms that get thrown out, such as this, a close relationship. But what a close relationship is for me may be very different to what a close relationship is for you. So the Act then looks at defining what these relationships are. So a close relationship means a relationship between the abused person and any other person, taking into account the following: the degree of trust between the persons, the level of dependence on and commitment to the other person, the length of time the relationship has existed, the frequency of contact between these persons, or the degree of intimacy between the persons. Now, examples of close relationships could include a friend who is you either live with, or one that is always that you have very close trusted relationship with. It could be a neighbor who is a very good friend. It could be the abused person's romantic partner. So if you can see, this is something where there's a close bond between the two persons. Now, what the Act also refers to when it talks about a domestic relationship is it refers to domestic relationships of family members. But not only does it speak to family members, it speaks to family members related by consanguinity, affinity, or adoption. Now, don't worry, when I first read the word consanguinity, I had very little idea what it meant, but it is unpacked in the definitions to mean that it's a person sharing a blood relationship. So it could be a daughter, a granddaughter, a grandparent, an aunt, an uncle, so anyone that you are related to by blood. Whereas affinity means a relationship because of marriage. Now, this could be in-laws relationships, or it could also relate to husband and wife. And by adoption, we talk about anybody that has been adopted into a family. So that could be an adoptive parent. It could be a child that has been adopted into a family. So these are the three forms of family members that the Act defines. Now, a relationship is not always that simple. The Act also refers to a person who is or was engaged, dating, or in a customary relationship, including an actual or perceived romantic, intimate, or sexual relationship. Now, what do we mean by actual or perceived? Well, an actual relationship is when two people agree we're in a relationship. We are in a romantic or an intimate or a sexual relationship. A perceived relationship is a little bit more tricky. A perceived relationship is when one person thinks they are in a relationship with another, but they are not. So maybe you are in a relationship or you are in a friendship with someone, but in your mind, this is far beyond a friendship and it's actually a romantic relationship. But for the other person, they don't think this is a relationship at all, but there is domestic violence that happens within that. And because one person perceives it is a romantic relationship, it is constituted a domestic relationship. All a little bit tricky, I think, but something that we need to grasp and have a common understanding of. So when we implement the law, we know what constitutes a domestic relationship. The last thing I want to look at before we start looking at what it actually means to receive a domestic violence complaint is, well, what is domestic violence? Now, this list of acts of domestic violence here will look quite familiar to you if you have worked in the domestic violence sector, but there are a couple of changes that the amendments have brought with it. And these here are highlighted in red blocks. The first is spiritual abuse. Now, spiritual abuse has always been considered an act of domestic violence, but has not always been clearly understood or defined. Well, the Act now makes it very clear that spiritual abuse is a form of domestic violence, and it can take three different forms. The first is to advocate hatred against the complainants because of their religious or spiritual beliefs. The second is preventing the complainant from exercising their constitutional right to freedom of conscience, religion, thought, belief, and opinion. And the third is to manipulate the complainant's religious or spiritual convictions and beliefs to justify the use of violence. So for that last one, you may find that an abuser will use a religious text taken out of context to justify their use of violence against the victim. The second inclusion here is the exposure of a child to domestic violence. Now, this brings the Amendment Act in line with the Children's Act as amended, and what it is saying is that just the mere exposure of a child to violence is considered an act of domestic violence. So it doesn't require the act of violence itself to be perpetrated on the child, but just by them witnessing, it does then constitute domestic violence. We also see the inclusion of related person abuse, and this is where either the respondent uses someone else to perpetrate the abuse or perpetrates an act of domestic violence against a related person to the complainant. Finally, elder abuse. This is something that has now been included as a separate category and again brings the Amendment Act in line with existing legislation, and in this instance, the Older Persons Act of 2006. One thing you may note that is missing here is stalking. Now, stalking is one of the areas that was hotly contested during the legislative amendments process. And what was finally decided is that stalking under the Protection from Harassment Act is covered, but covered under harassment. And that's very important to note, that if someone comes to you to say, I'm experiencing domestic violence, and they explain stalking to you, that you know this is still included, it's just included under the definition of harassment. So now, hopefully we have a better understanding of what constitutes a domestic relationship and what constitutes domestic violence. So let's take a look at what the role of SAPS is in receiving a domestic violence complaint. Apologies, just a sip of water. My throat's getting a little bit dry. So the first step, the complainant approaches the SAPS station, or a SAPS member attends a domestic violence complaint. So what now? Well, first and foremost, you need to ascertain the nature of the complaint. Is it, in fact, domestic violence? And that's why I thought it important to go through what is domestic violence and a domestic violence or domestic relationship before coming to the slide. So now we've ascertained that it is domestic violence. The next is to consider, has a crime been committed? If yes, then we need to ascertain whether the complainant wants to open a criminal case. Now, it's important to note here that we're merely establishing if a crime is being committed to know whether a criminal case needs to be opened. It is not to determine whether or not to assist the complainant. The complainant will always be assisted, but here we know domestic violence is still considered a civil matter, but within it, acts of domestic violence are constituted as offences. So we're trying to see what are the next steps. So we've ascertained a crime has been committed. So this could be assault GBH, it could be an act of sexual violence, but we've ascertained it has been committed. So the complainant, do they want to open a criminal case? Yes, they do. So what should we do? Well, the SAPS member needs to open a docket. And from there, the docket would then be sent to the detectives for further investigation. But what if a crime has not been committed? Well, if a crime hasn't been committed or an offence has not been committed, let's put it that way, there is still an obligation on the SAPS member to assist the complainant. And how should they do this? Well, first and foremost, we need to assess, is the complainant in need of protection through a shelter, or do they require health facilities or assistance through a healthcare facility? If yes, then the SAPS member needs to provide the complainant with a list of shelters, and the Act is very clear on how this list should be provided. It is not to include any addresses of the shelters themselves, but rather just the contact numbers for the shelters, as well as the name, address, and contact number of healthcare facilities within the area served or where the complainant resides. So here you'll see it's very important that the SAPS station has a up-to-date list of service providers. Now, these forms must be provided to all complainants, not only complainants who don't have an offence committed. So you'll see there's a little arrow that goes from yes there as well. So that's the first form. The second form that needs to be provided to the complainant is the Notice of Rights and Steps for Protection. Now, those SAPS members that are on the call and those of us that have worked in the domestic violence sector for a while will know of Form 1. So that is the form we're speaking about now. It's previously Form 1, but under the draft regulations, it is now known as Form 5. And this notice explains the role of the police, and it also includes information on the right of the complainant to open a criminal case, apply for a domestic violence protection order, either in person at a magistrate's court or electronically, and it also outlines the process of applying for the order, the issuing and finalization of the order, as well as reporting the breach of the order. Now, for those who, just a note here, for those that do not currently have a copy of the draft regulations and the forms, they are available on the Department of Justice website. Otherwise, please get in contact with the Pillar 3 Secretariat to share a copy of this with you. What you will find is there are many more forms than what are currently on the Act. If I'm not mistaken, the Domestic Violence Act has 13 forms. The Amendment Act has made provision for 40 forms. So there's a lot more forms that are going to be included. So the form numbers I speak to through my presentation are the forms as annexed to the draft regulations. Now, one other important thing to note here before I move on is that it is still the responsibility of SAPS to record every instance of domestic violence in the prescribed manner. Now, previously, we looked at forms such as the 508A and 508B, as well as any notes taken in the member's pocketbook. But these form numbers may change based on the revision and alignment of the SAPS national instructions. So I'm just noting that here. It's not necessarily noted in the Act itself, but is noted in the current national instructions. Now, when we talk about SAPS's intervention or police intervention in domestic violence matters, the amendments have strengthened the provisions for police intervention. So the provision in the Domestic Violence Act was simply this: a peace officer may, without warrant, arrest any respondent at the scene of an incident of domestic violence whom he or she reasonably suspects of having committed an offence containing an element of violence against a complainant. That was it. Well, the new provision is more expansive. It expands on this to specify that it needs to be any incident of domestic violence. It also speaks to a police officer being able to arrest any respondent at the scene of domestic violence who they believe has committed an act of domestic violence and can do so without a warrant, but also allows for the provision to enter the private residence for the purpose of obtaining evidence, and not just entering as in knock on the door and take a step inside, but actually allows for forced entry if needs be. And that is detailed quite extensively in the regulations, but will also be outlined in the SAPS national instructions. But what this really is aiming to do is to provide SAPS with the maximum measure of support of the law to be able to access a complainant who is in harm's way, and to be able to gather the evidence needed to prove domestic violence took place. Now, there's been a lot of talk about the Domestic Violence Safety Monitoring Notice. This is a brand new provision within the Amendment Act, and I'm just going to show you here how it fits into the process. So, in the process of applying for a domestic violence protection order, and we don't need to go through this whole process, but it is just important to see what some of these new provisions are. So here we have, there's an electronic repository for the central storage of documents. An application for a protection order can be made in person or electronically. And here where we're focusing on now is the introduction of a safety monitoring notice. Now, what is this notice? Well, a safety monitoring notice is a court order that aims to prevent further violence when a complainant and respondent share a joint residence. Now, in my work in the domestic violence field and speaking with many SAPS officials during my time in the sector, this has been something that has been really troublesome for police members or police officers, is how do you prevent violence from happening where the complainants and respondents share a joint residence? And this is where the safety monitoring notice comes in, is to say, well, let's try and find a way that we can prevent these further acts of violence. So who can apply for this? It's not available to anyone who's experienced domestic violence. It is only available for when the complainant shares a joint residence with the respondent and is fearful of experiencing more harm as a result of the respondent's use of violence. This is applied for at the same time as applying for a protection order or any time during the process of the application being finalized. Alternatively, if the process is finalized, so the complainant has their final protection order, they are then able to still approach the court and say, I'm fearing being harmed. I share a residence with my abuser. Could I please apply for a safety monitoring notice? So that's what it is, but how is it actually operationalized? And what does this mean for police stations around the country? Well, the safety monitoring notice, as much as it is a court order, is really operationalized almost 98% by police. And it's done so in this manner. So the court issues a safety monitoring notice, which is also known as Form 10. Once the court issues the safety monitoring notice, it is the duty of the clerk of the court to serve the safety monitoring notice on the station commander of the police station that serves the district of the residence or where the residence is. This can be served either electronically or by hand. So either it's collected from the court or the clerk takes it to the police station or sends it through an approved electronic channel. Well, then what happens from there? Well, the station commander is then required to assign a SAPS member to immediately serve the notice on the respondent. And it follows the same process as serving the interim protection order or the final protection order. The service can also be done at the same time as serving those documents. Once served, there is a requirement for a return of service to be completed, signed, and handed to the clerk of the court. And this is now known as, the return of service is now known as Form 40 and can be done by hand or electronically. Again, the electronic component of the Amendment Act and its regulations will be further explained through directives and national instructions. So, like the interim protection order, the safety monitoring notice can only come into effect once service has been made on the respondent. So let's assume we have, the court has issued the monitoring notice, the clerk has given it to the station commander has assigned a SAPS member who has successfully served the notice on the respondent. What happens then? Well, the station commander then is required to assign a SAPS member to contact the complainants at regular intervals. Now, I know through Mosaic's interaction with domestic violence or gender-based violence coordinators that this is something that has already been happening, but on a quite ad hoc basis. It hasn't been something that's been regulated. Well, this now is regulating this check-in with the complainant. Now, the complainant check-in or contacts could be done in electronic service, so either via SMS, WhatsApp, email. Again, this will be outlined in the national instructions, as well as visits to the joint residence. And during these visits, the SAPS member must be able to speak to the complainant in private. And the reason for this is they're really wanting to check in to see, has there been other acts of violence? What are you currently experiencing? Do you feel safe where you are? And if not, then to take the appropriate action. And that'll be quite difficult if it's done in the same space as the respondent. This provision also makes provision for the SAPS member to gain access even by force, to overcome resistance where access to the complainant is prevented. So it even speaks to the breaking of windows or breaking down of doors if necessary to enter the premises. Now, this is all fine. So we have the notice, we've gone, we've made the necessary visits and connections with the complainants. What then? Well, the safety monitoring notice is not like the final protection order. A final protection order does not expire. It is, if you have one from 1999, when the Domestic Violence Act was first promulgated, your protection order is still valid. This is not the case with the safety monitoring notice. The safety monitoring notice will be in place for a time period decided by the court. It may be a couple of weeks, a couple of months, but that will be decided by the court. Once that period has expired, the SAPS member will be required to submit a report in the prescribed manner. Again, this will be outlined in the national instructions and regulations, but this report needs to be filed with the clerk of the court. And the report needs to include what was your nature and frequency of communications. So how many times did you message electronically? Did the complainant respond back? How many visits did you make to the residence? And how often did you do this? It also needs to include any information on any harm or violence experienced by the complainant during this time, and any criminal cases that were opened during this time, and that's submitted to the court. So this is, as I said, a new provision. It's something that will require quite a bit of coordination by SAPS stations specifically, and it is something that is dealt with at a station level. And will require SAPS members to be assigned and dedicated to doing this role. So something I'm just flagging while SAPS stations wait for instruction from the national office, to just start thinking, how would I start implementing this in my station? Let's look at the service of documents, something that I know SAPS stations are doing regularly already, and something that will continue under the amendments. Now, the service of documents is so incredibly important, and it's a part of the process that, if not done in the correct time frame, or if not done in the way as it's set out in the regulations, directives, and instructions, could have a serious impact on the safety and protection of the complainant. This is especially because the interim protection order and the safety monitoring notice do not take effect until the respondent is made aware of these documents or service has been done. So what is the responsibility of SAPS and the role of SAPS in the service of these documents? Well, in the amendments, or now Section 13 of the Act, provision is made for documents to be served at the residence, place of business, employment, or study. Now, the Act makes provision for the service to be done by the clerk of the court, the sheriff, or a peace officer. But further to this, in the draft regulations, Regulation 32(1)A mandates that where service is required by hand, that service is to be carried out by any member of the South African Police Service unless ordered by the court. So that's just something to keep in mind. This is not something that was included in the Domestic Violence Act, but this is specifically saying that it now specifically states that any service required by hand is to be carried out by a member of SAPS. Another provision that is made quite clear in the Act is that where the complainant and a respondent share the same residence, the service of the documents cannot be made on the complainant, for instance. So where you may before be able to serve documents on another adult person in the home, where it is the same residence, documents must be served on the complainant or the respondent themselves, so in person, because the last thing you want is for the service of documents to be made on the complainant, who then has to serve it onto the respondent. Finally, the last note on service is that where the court is satisfied that service by hand could not be effected, the court can order that service take place in another prescribed manner. So that might be electronically or another manner that the court decides. So there are a few extra forms and documents that may be required to be served through this Amendment Act, and these are listed in the table here on the right, and all the form numbers that I have included are those that are included in the draft regulations and annexed forms. So now the court has issued the protection order, whether it be the interim order or the order has been finalized. A member of the police has served the order onto the respondent, and now there is a contravention of the protection order. What now does the Act require of the police? So here you'll see I've put together a little bit of a process chart. I know there is quite a bit of text on it, but let's work through it, and hopefully you can also revisit this after the session. So Section 8, Parts 1 to 6, make provision for the issuing of a warrant of arrest. And that warrant of arrest is issued with the protection order and allows the use of the warrants on contravention of the order by the respondent. Now, the process that the Act and the regulations speak to is that on contravention of the protection order by the respondent, the complainants can hand the warrant of arrest, which is known as Form 33, to a member of the police. And this should come along with an affidavit that states what acts of domestic violence and what provisions of the order were contravened by the respondent. And that affidavit is prescribed in Form 35. Now, at this moment, when SAPS arrives at the scene of a domestic violence complaint, or the complainant comes to the station themselves, again, the SAPS member needs to establish whether or not there are reasonable grounds for the suspect or to suspect that the complainant is suffering or may suffer harm as a result of this breach. Now, we'll look in just the next slide what some of the components are to take into account when considering this harm. But let's say that the SAPS member has established that there are reasonable grounds that the complainant is suffering or may suffer as a result of this breach. Well, the Act then mandates that the SAPS member needs to immediately arrest the respondent using the warrants of arrest on Form 33 and are arresting the respondent for allegedly committing the offence. If, on the other hand, the SAPS member looks at the merits of the case, looks at the affidavit, has spoken with the complainant, and sees that actually they don't find sufficient grounds, so they find insufficient grounds for arresting the respondent, what do they need to do? Well, they need to immediately hand a written notice to the respondent informing them that they need to appear in court. For SAPS members on this webinar, that's previously Form 11, or the current Form 11, which will be replaced with Form 36. And it's also important that this note at this time to explain the importance of this notice to the respondent. And from here to immediately forward a duplicate copy of that notice to the clerk of the court. This is the one instance where a return of service is not required, and this duplicate notice serves as evidence of service. So those are the two things that SAPS needs to establish. Is there reasonable grounds to suspect that the complainant is suffering or may suffer harm? Yes, arrest immediately. If not, there needs to be a notice to appear in court provided to the respondent immediately. But in all instances where there is a contravention of the protection order, it is the responsibility of the SAPS member to inform the complainant of their right to lay a criminal charge against the respondent and how to go about laying that charge where applicable. Now, as I said, talking about amendments and considering harm, in the Domestic Violence Act, there was this term called imminent harm. Well, that term has been removed. That term has been removed and replaced with only looking at, is there a possibility of the complainant suffering harm, or will they suffer harm because of the breach? And to assist a SAPS member to make that determination, these are some of the points that have been raised in the Act to assist in determining harm. The first is to consider the risk to the safety, health, or well-being of the complainant, as well as any related person or any damage of their property. The seriousness of the conduct comprising an alleged breach of the protection order, the length of time since the alleged breach occurred, and the nature and extent of the harm previously suffered in the domestic violence or in the domestic relationship by the complainant or a related person. So there's a lot contained in there, but it really is trying to see, well, what is the risk that this breach could lead to more serious harm or any form of harm to the complainants. Now, the final section in terms of the role of police under the Amendment Act is around the seizure of weapons. Now, again, there's been a change of language. The language in the Domestic Violence Act spoke specifically to an arm or a dangerous weapon. Now, this again led to some confusion or a lack of collective understanding of what constitutes an arm or a dangerous weapon. Well, the Act aims to clear this up. The definition of weapon, as included in the Act, the Amendment Act, speaks to firearms as defined in Section 1 of the Firearms Control Act. Again, you can see bringing the legislation in line with existing pieces of legislation. But then here, the important addition is any object other than the firearms, which is likely to inflict grievous bodily harm or a dangerous wound if it were used to commit an assault. Now you can see this is much wider than just an arm or a dangerous weapon. It needs to be any object that can cause harm. Now, on order of the court, a SAPS member would be ordered to remove any weapon as defined in the Amendment Act from the respondent, and this removal is regardless of the requirements that respondent's employment has for them to carry such a weapon. The SAPS member or SAPS themselves has to retain the weapon in custody until a time determined by the court. It also speaks to providing a distinguishing mark and storing it in a specific way, but again, this will be detailed in the national instructions. And finally, on the granting of a final protection order, the station commander must make determination of the fitness to hold a firearm license for those respondents who hold a firearm license, and such decision needs to be communicated to the National Commissioner. Now, I know that's a lot of information around the Act itself, but I wanted to also use this opportunity, if I may, to speak a little bit about the role of police as a first responder in receiving a domestic violence complaint. In our experience as Mosaic, working in the field of domestic violence and intimate partner violence and gender-based violence more broadly, there's one thing that comes up time and time again, and it's this concept of secondary victimization or secondary trauma. And this is often experienced by complainants when they approach first responders. So what do I mean by a first responder? Well, a first responder is anyone who could be at the front line to witnessing or receiving information about domestic violence. And these could include police, justice officials, Department of Social Development representatives, religious and traditional leaders, NGO representatives, even your community policing forum members, health personnel, and the like. I'm sure you can think of a lot of people within both your professional and community context that are at the forefront of receiving this information. Well, in research carried out by Mosaic and the UCT Gender Health and Justice Research Unit last year, we found that many of these first responders, and in this instance, we spoke to justice officials as well as SAPS members, many first responders felt quite ill-equipped to receive complainants, especially in the context of domestic and sexual violence. Now, I need to note here that they don't feel ill-prepared to receive complainants from a procedural side, but rather from a psychosocial trauma component to the job at hand. So I wanted to share just a few tips to assist with receiving a victim of domestic violence, and this is specifically looking at with police having a very frontline role and often being the first port of call for someone who has experienced violence and often quite a serious nature of assault or assault GBH coming into a SAP station, what is it and how should a first line responder receive such a complainant? So if I may, this will only take a few moments, just some of the key tips that Mosaic would like to put forward. So the one is, make sure you prepare for the consultation. Look at your space where you work. Is there a private or confidential space that you are able to take a complainant to? Now, we know that the areas that we work are not always conducive to having a room dedicated to taking a complainant to. But is there a space within the CSC or within the court building where you can carve out just a space where there's not a lot of people around you, that you can speak to the complainants in a confidential and private way? If you find that there are other people around, try and just keep your voice down and don't repeat sensitive information. Remember, someone coming into the space is already feeling like they are exposing everything that is happening and they've already experienced a traumatic event. Secondly, know what services you are able to provide. We can't always provide every service, so we need to be confident and know this is what I can provide to the complainant. And then keep up to date with changes and amendments to processes and legislation, so when you provide information to the complainant, it's accurate. What do you do during the consultation? So you've prepared for it and now you have the complainant in front of you. Well, firstly, it's important to let the complainant know if you have an obligation to report. So if you are a police officer and someone comes to say, I know of violence that's happening and I just want your advice, and it comes out that it's violence against an older person, you know that you have to report it. But so it's important to let the person know that you have the obligation to report. At times that might seem like they're a little bit hesitant to share with you, but at least you don't put yourself in a position where they share everything and now you need to go and report and they do not want you to. It just places you in a really difficult position. But also if you are able to speak to them and explain the importance of reporting, many complainants will come around and still tell you what is happening. When asking questions of the complainant, avoid cross-examining or passing judgments. Now, I know what happens, you're busy, the CSC is full, it's a Saturday night, it's full, someone comes in to report a case of domestic violence, and often you are so in the mode of taking down the complaint that you're like, well, where did this happen? What time did it happen? Who was there? Who saw it? Who else was in the room? And for someone who's coming in, that can be seen as very anxiety provoking. So you want to move to a private confidential space and try asking questions like, what is your name? Whereabout do you stay? And rather having a conversation about what has happened, and not passing judgments of, well, it's 2:00 in the morning. What did you think was going to happen? Sort of thing. And then take time to listen to the complainant's story and understand that the complainant will not always know the different forms of domestic violence they may have experienced. And this is an opportunity for you to share with them or identify other areas of domestic violence. And then take time to ask some clarifying questions where you are not clear. Finally here, don't ask questions that shift blame on the victim. Now, victim blaming is something where a victim is blamed for someone else's actions. So for the domestic violence victim, they're basically being told, you are responsible for this act of domestic violence. So one of these might be, well, why don't you just leave? It's your fault. You stayed with him. Of course this was going to happen. That's an example of victim blaming. And then just on to my final slide is, what do we do after the consultation? Well, following the consultation, in whatever role as a first responder you play, you provide the mandated service as prescribed in the directives, the regulations, the national instructions. And where you are not able to provide a service, refer the person for additional and/or follow-up services. Again, as I mentioned, we can't do everything. We need to work in a collaborative way. So it's important that you keep up to date with what is happening within the community in which you work. And finally, the question we always get asked, well, what about the return complainant? We hear stories of frustration from first responders, specifically police and court officials, of the complainant that keeps on coming back, but opens a case, withdraws a case, comes back the next weekend with the same complaint. It's not unusual for a complainant to return for a follow-up service or for the exact same service. But it's not your responsibility as a first responder to pass judgment or refuse to assist them, but rather to assure them that domestic violence is never okay and that you will still do your best to assist them. As frustrating as it is, do also be patient with the complainant as they share their current experience. I know that's sometimes quite difficult to do, But that brings me to the end of my presentation. I thought I would just include those key tips, especially as we're moving into implementing the Act in just a few short days, really, not even weeks anymore. So I wanted to share just a couple of those tips. And please, if you're interested in the work that Mosaic's doing around preparing first responders, please get in contact with me, and we can share some of the material that we have around first responders and having them ready. Also, next week, there will be another webinar that looks at the dynamics of domestic violence and how that impacts the complainant's help-seeking behavior. So I encourage you to join that webinar next week, Thursday, as well. But for now, thank you so much. I know it's a lot of information. And Gregory, I see I've only given you a few moments for questions, but thank you so much for your time, and I hand over to Gregory.
Karen, thank you so much. That I think that you have done justice to the process and also looked into a number of key issues as well. That you have also touched a number of key issues then international instructions. Technically, that what you've presented today, that it simply means that the national instructions may have to be urgently written as well, in order to accommodate then the new changes in terms of DVA in the country as well. That and a number of key issues that you have also raised when it comes to that as well. That before I'm going to allow questions or comments, I'm going to ask the Advocate Praise just to in 2 minutes just to tell the team that when is the implementation process happening and the date that when it's going to happen as well in the country. Over to you, Advocate Praise. Thank you.
Thanks, Gregory. You are putting me on the spot here. As everybody knows that the president announced in his speech for budget vote for the office of the presidency that the date of commencement will be will be on the 31st of July, but then we are translating that as the 1st of August. That is the date of the announcement of the commencement date. So, but it is still standing as what was announced. But right now, we are actually, taking a microscopic consideration of the country readiness for the implementation of the 3 Amendment Acts, and so as to give the president a proper advice as to whether is our country ready for this implementation. But then it's not a matter that I would like people to go back to say that the date might change, all right? It is his prerogative to set that date and to announce it to the general public. So he might not, it doesn't matter what advice that we give. So he's the one who will make the decision. Otherwise, that's where we stand right now. Thank you.
Thank you, Advocate, for that. I had to do that because for 2 reasons. One, that we should exactly know that how serious this business has become now in terms of the issue of what is kind of happening in the country as well, that where we basically have cases that which have been 9 years on the roll, 40 times we postponed as well in some other provinces dealing with the matter as well. And women still receiving the best and the worst out of it as well in this country, and young people, especially young women as well. And it's about time that the prices needs to change when it comes to this well. That without wasting any time, that any person then wants to raise a comment or wants to ask a point of clarity or question, that is willing then to raise his or her hand as well, dealing with it. But at the same time, I'm also going to put Professor Parker on the spot here as well, that do you also get a comments then on the matter as well at the same time? Dlamini, you can raise your issues. You're welcome to start raising it. Thank you. Over to you, Dlamini.
Okay, good afternoon, colleagues. I would like to know if, with regard to the safety monitoring tool, if the respondent refuses to sign because it's the same with the protection order, what needs to happen? Thank you.
Thank you. Malisela, you can post your question or your comment.
Thank you so much. My question is around the issue of serving of documents. I just need to find out because I think in the previous it was indicated that it needs to be served within 24 hours, more especially the protection orders. Now, my concern on that is what should happen in the case where the suspect or the respondent is not traceable, and what should the police do with the process? Are we supposed to be returning it back, or what are we going to be having an extension as compared to previously, where it was only indicating that without delay? So if it still stands in terms of 24 hours, are we not putting the life of the respondent in danger, where after 24 hours, then that means the process is expired? Are we also not putting the life of the police at danger, where we cannot be able to serve after 24 hours because a respondent will not be accepting the process that is serving that we are serving him after 24 hours? Just the question of clarity, please. And number two is the issue of the DV safety monitoring tool and notice as well. Are we also having a time frame on which the respondent is supposed to be served on that? Thank you.
Okay, thank you. Can I ask MF then? You've also raised your hand then to also raise a question. Thank you, MF. Okay, while waiting on MF then, I'll give the first question then to Advocate Kambula, and then the second one as well. And then you can also comment in Karen into that. Thank you. Over to you, Advocate.
Hi, Gregory. Can I respond after the presenter, please? After Kiran.
Okay, thanks. Kiran, over to you. Okay, thanks.
Thank you so much for your questions. It's lovely to have an audience that is engaged and interested in the amendment. So thank you so much. Let me speak first to the safety monitoring notice. In terms of the respondent refusal to sign, the Amendment Act makes provision for the respondent to be aware of the notice. So that needs to be really spelt out in the regulations and the directives. So once the regulations and directives are finalized, we'd be able to see what provision has been made. But also in terms of a respondent not being traceable, or for service not to be affected, what can happen and what the Act does make provision for is for police or another peace officer to go back to the court to say we were not able to serve this, and it might be because of refusal to sign, it might be because the person is untraceable. The court can then order an alternative method to serve, and that the Act also makes provision for electronic service. So there may also be that option for service, so that we don't limit the protection for a complainant or a person experiencing violence. In terms of the time frames, remember the regulations that were put forward did propose 24 hours. Those were draft regulations, and I know that the concept of the time period was brought up quite substantially during the webinar. I think it was on the 6th of this month. So I am sure that SAPS Legal Service has presented their comments on the regulations. So I can't confirm that it will remain at 24 hours. Currently, it does stay 24 hours. But again, if there is reasonable evidence to the court and conclusive evidence to the court that service could not be affected, the Act does make provision for alternative methods of service.
Okay, thank you. Advocate, over to you.
Thank you, Gregory. I would also like to say here that the Act makes provision for the places where the service should be made. So if then you can't find the respondent at the residence, you can check him at the place of business, at the place of employment, and also if it's a student at the place of study. All right. So you have all those options that you need to exhaust first before you can go to court to say that the respondent is not available. And the reason for the act to for the regulations to specify this period as 24 hours, it is because we have found that many women die between that time, between the issuing of the interim protection order and the service thereof. And we have experienced a lot of challenges where the protection orders lie, in the police desk and so on without being served. And that's a very, very, very dangerous moment then for the complainant, because the word goes around to say that we have seen her or him, in court and so on. And there's a possibility of a protection order coming through. So they die during that period. So then they have to be served very quickly. And I will say that if police will be coming with a counter time period for the service, it's something that will be debatable. All right, because for us, we have a reason for us to place that 24 hours to ensure that the service is done immediately. So, and I would also like to say here that we have also ensured that the national directives, which are for other departments that are quite relevant here, and also the national instructions for the police. I know that I have been informed that they've actually now moving from the zero draft to the first draft of the national instructions. All right, so they have to include a disciplinary measure, all the national directives, all right, for all the disciplines that are relevant in the management of the protection orders. If there is any non-compliance with any task, duty, responsibility, obligation, and so on, there must be a serious disciplinary measure that is taken, and that includes as well as it also includes the secondary traumatization of the victims. So it's one area that we're going to be checking and ensuring that in all these departments that are expected to develop the national directives, all right, including with us at the Department of Justice, our clerks of the court, and also the national instructions, we are not going to permit any document that does not set out the disciplinary measures. Thank you.
Thank you. Okay, two things that Tembekile, you are next. You did raise your hand, and then after that, Masilela as well. Over to you, Tembekile. Neil, can you raise your comment then, or your question as well, Neil? Over to you, Neil.
Hi, good day. There was actually a question that I was asked today at on our meetings that we had. They wanted us to further elaborate on the electronic service, the different modes of electronic service. I'm not sure she was talking about a portal or what are the different modes that we would be using.
Okay, thank you. MF, over to you. I see you've raised your hand as well. Your comment or your question or point of clarity?
Okay, yeah, it's a follow-up. Sorry, man. I'm not concerned regarding the non-compliance of the police. That I understand that the internal disciplinary process has to be tightened there. But my worry is the time where the respondent is not traceable. Because remember, in most of the time, you'll find that the respondent will run away because he knows that he is in trouble. Now, I just need to know the period there, because now we are having 24 hours and it expires. Then let's say it expires on a Friday, then the whole weekend the victim is exposed to danger. My concern is around the victim, not around not the saving of that, but how do we ensure the protection of the victim while we are tracing the respondent and it's not traceable, number one. Number two, now what remedies are we having there during that period where we still have to wait to go back to court and give the information to say, listen, this person is doing the duck and dive. Now, I understand the electronic saving, but in most of the time, it might also be a challenge. Now, a typical example of somebody who is not traceable, for an example, I'm saying, let's say a person is a taxi driver from Limpopo to Cape Town. Now, in that process, 24 hours is going to expire before he can come back, because in the process, he does not have an office in between where he is going to be stopping and say, okay, this is my office where it can be saved. In the process, we cannot be able to say, okay, let the highway patrol run after him to go and find the taxi wherever, the truck wherever he is, if he's crossing the border, for example. So I need to know, in the case where 24 hours is not workable, what remedies of protection, not the non-compliance of the police, the remedies of the protection towards the complainant. That's all I need.
Okay, Karen and then Kambula. Karen, over to you.
Gregory, are you for me?
Yes, okay.
Okay, so sorry about that. So Tembakile, first your question around electronic service. So it's the regulations speak to a prescribed manner. So it will differ from department to department, and that will need to be outlined within the directives and national instructions. I haven't included the directives here. It will all be detailed there. At the moment, I don't have the exact information. There's a couple of different modes. The one would be either through, the Act speaks to a designated electronic address, so that would speak more to an email address, but there's also been discussion around SMS, WhatsApp, and through an electronic portal. So those are things that will be phased in through time. For now, it's looking at where there are modes of electronic service, so whether it be through email, using a read response, or something like that. But that will be defined through the directives as well as the instructions for the various departments. Then in terms of when someone is not traceable, Freddie, if I am correct, your question is really out of concern that if that 24-hour lapses, does that mean that the police are not then able to serve that document outside of the 24 hours? I'm just checking if I've got that correct.
Yes, Karen, yes.
Okay, so I don't want to speak out of turn. I think that this is a provision, as Advocate Kambula has shared, it's a provision that's been put in place because in some instances, there's been 3 to 6 months and an order has not been served on a respondent as yet. But I do not think that the court will say that the document is invalid because the interim protection order would carry a specific period of time that it is valid for. The instruction or the provision here is really about that service must be effected within this time, but if it is not reasonable to do so, the Act then makes provision for other forms of service. So it would need to really be specified within the national instructions as to what steps would be taken within that 24 hours, followed by, if not within the 24 hours, then what? Yeah, that's the best that I can answer. Unfortunately, I'm not in the rooms of the powers that be in terms of determining what then after the 24 hours, but a really great question, and I think something that will need to be considered, because it could run into a challenge where a respondent could say, well, this was issued on Friday, but you're only serving me on Monday, so therefore it's not valid. So thank you for that question, and hopefully the legislators around us and in this forum would be able to take that forward, just to be able to clarify it before the regulations are finalized.
Okay, Advocate, to you, your comments on the matter, Advocate.
All right, may I just add that
Thanks, Grace.
the clerk of the court and any functionary has to advise the complainant, including the police, that you need now, if you believe that there might be further retaliation and your life is in danger, quickly apply for the domestic violence safety monitoring notice, so that you have your protection during that time, as the police are looking for the respondent. So because the monitoring notice places a duty on the police to keep constant contact with the victim. So it's something that as this question is coming through, I'm thinking that we have to incorporate it in all the national directives of the functionaries and so on, so that it is reflected there. Thank you so much for such a brilliant question.
Thank you. That Katekani Committee Project, you raised your hand. You may proceed now with the question or your comments as well. Thank you.
I'm not. All right. Thank you so much, Chair. This is Cedric from Katekani Community Project in Winterveld and Mabopane. Yes, my question reads as follows. I'm looking at the slide where you indicated that when there is a contravention of the protection order. So I'm saying that you said that on your slide that the complainant hands warrant with an affidavit detailing the contravention of protection order by the respondent. So I'm saying that when determining whether or not there is a sufficient grounds for arresting the respondent, in the event, when you are busy determining that. So I just want to check on in an event whereby deem that particular affidavit not having sufficient grounds for warranting arrest, would that not serve as a first responder victimization on its own? That is my question, Chair. Thank you.
Okay, Carol, you can answer straight away. Okay.
Cedric, again, a fantastic question, and I can see that definitely comes from a practitioner who works in the field and is knowledgeable of the challenges that are experienced by complainants for domestic violence. So what would happen? I mean, if you think about when you're going to a police station to report a criminal case, and a contravention of protection order would be considered to be a criminal matter. So when you're going to the police station, the information that you share gets taken down into an affidavit. So the act, the Domestic Violence Act, said the same thing as the Amendment Act, that you would need to hand over an affidavit. But more often than not, that affidavit is done at the time of reporting a contravention. So it would either be taken down by the SAPS member on duty or completed by the complainant themselves, and included with a copy or included with the original warrant of arrest. So there are two ways here. The one is when you're detailing the story, so as a civil society organization, to really empower the communities that we serve to know what to detail when you go and report a contravention, to include all the information that led up to the act of violence as well as the act of violence itself to the SAPS member, so that they have a very full story, or not a story, full facts of what happened with the contravention of the protection order. That then gets compiled into an affidavit, which is then signed at the station itself. So while the Act speaks to handing over an affidavit, it often does happen at the time of reporting in the CSC. When a SAPS member goes out to a domestic violence complaint, they will take other matters into consideration. So if they arrive at a space and they can see that there is broken, maybe there's broken cups, or there's a knife lying out on the table, or a respondent is being violent towards the complainant at the time, they could make a determination of harm right there and then based on what they are observing as well. So I don't know if that helps your or answers your question, and I do invite any other legal mind or SAPS mind in the room to maybe share what their experience is of implementing this provision that's made in the Domestic Violence Act as well, where an affidavit is required when reporting a case of contravention.
Okay, Advocate Kambula.
Gregory, my battery is down. I'm going to be switching to the cell phone. I've just received the link from Luando. Would you just allow me to get to the other device? Thank you. I'm going to be leaving this platform.
Okay, I'll ask in the meantime Patricia Koshwari to raise your comments or your question you have raised, and followed by Delia Banadia. Patricia, over to you.
Good day, sir. Just wanted to find out, I heard ma'am talking about domestic violence that includes now friends. Just want to find out, is it now going to be taken out from the Harassment Act and now be on Domestic Violence Act? Number two, I'm very worried when it comes to SAPS return of services. What they normally do is that you'd find out that maybe it will only be a signature of the respondent, and then they are not. It's not signed by whoever official served to the respondent. And again, they are also refusing to open criminal cases for them on condition that they apply for domestic violence. I don't know whether it can be. Let me put it as a version to say, if SAPS can be included when it comes to these trainings, because you'll find out that they are not aware of what actually they are dealing with. Instead, they would want people to open domestic violence before they can do their day-to-day jobs. Thank you.
Thank you, Banadia. Over to you. You've raised your hand, your comment or your question. A point of clarity.
Thank you very much, Karen, for a very informative presentation. So my question is basically, I know the domestic violence term is broader than intimate partner violence per se, but specifically now when it comes to the domestic relationship of affinity, the Amendment Act has specifically omitted the word repeated incidences of abuse. So in other words, just a once-off can be, reported. And a hallmark feature of intimate partner violence is this repetitive, coercive and controlling behavior. So in your slide, it was when we take a complainant, we shouldn't really cross-examine or cross-question or judge. But my experience in the field has been that very often abuse is bidirectional, and sometimes false allegations are made by the complainant, and with the result is that the system is being abused. So the question at the end of the day is, what stops are in place for the system not to be abused?
Could I go ahead, Gregory?
Thank you. Go ahead, Karen. Thanks. Okay.
So thank you so much again for some great questions. Patricia, in terms of your question around friends, no, it won't be removed out of the Protection from Harassment Act. Where we speak about close relationships being a close friend, it may be someone that shares the residence with the person, or there is an element of dependence or a very high level of trust relationship between those two people. But it really speaks to sort of where is that relationship taking place. So it's not going to be sort of a friend that harasses me is now domestic violence. It is really focused on the nature of that relationship. So is it two friends living together in res, for instance? So they're staying together and they're sharing a room in res, and one of them is then using domestic violence against that person, and they have this close relationship already. That would be considered a close relationship and a friend, therefore a domestic relationship. I hope that clarifies. Then in terms of the return of service, I take that on board, and it's something that again would need to be almost dealt with at a station level. So when it happens, to take it up with the station commander, and then also to follow those disciplinary procedures that are included or will be included in the national instructions. And it does make provision for that in the Amendment Act, as shared by Advocate Kambula, that all departments must institute disciplinary measures or have disciplinary measures in place for those members who do not follow the instructions or directives. Refusing to open a criminal case without proof that an application has been made for a protection order is something that I have been hearing for the past 13 years that I've been in the sector, and something again that can only be done through very regular follow-up trainings and refresher trainings, and you almost sort of need to have this consistent messaging about what is the actual process, because the act is clear, the legislation is clear that the opening up of a criminal case is completely independent to applying for a protection order. And so I do see a couple of SAPS members online, but it is something that for Mosaic, we do advocate quite strongly with provincial and national officers to make sure that there is this consistent messaging of the distinguishing between a criminal act and applying for a protection order, because they are two very different processes. But thank you so much for bringing that up and bringing it into the space. Then Delia, your question around repeated, the removal of repeated, and also the fear or the experience of false allegations and counter applications. So two things on this. The being part of the amendment process and the legislative reform process, there was quite a bit of debate around the use of repeated. Because what does repeated mean? How many times is repeated? What has to happen in order for someone to then decide, okay, now that's enough to be considered domestic violence? We also know that domestic violence increases in its severity, and it can take someone up to 7 years to finally report domestic violence. So, we sort of, the legislation needs to take into account that there are people who are experiencing violence and may only see physical violence as a form of violence, and therefore in their mind it's only happened once, but now it's serious enough for them to go say something, but actually they've had the controlling and coercive behavior before that. So that was where that thought of around repeated was. In terms of false allegations, so Form 5 that provides information on the on what the rights and protection and service are for complainants of domestic violence actually has very clearly in bold at the bottom of that form that states any false information provided is a crime. So there is sort of warnings around it through the process, but also what the Act is trying to move towards is that any existing applications or counter applications are actually dealt with together so that the court is able to make determination on the matters together rather than I go to court and I'm experiencing violence with my respondent. I go to court, I get issued with an interim protection order. My abuser then goes to court and also applies a different court and then applies for a protection order and gets issued a protection order against me. Now we have two orders that often contradict each other, and it makes it really difficult for SAPS to then implement the order or affect the order. And now you've got it being dealt with in different courts at different times. So there is a process underway for that to be determined at the time of application, whether there is another application, a reciprocal application that exists, or if this is a reciprocal application, or if an existing application is in the system. So that's one way to deal with those counter applications and applications being brought because of an existing application or two applications being brought at the same time. And there are measures in place for if it's established that there's false information, the state can prosecute the person for false allegations. So that's the thinking behind the removal of repeated, but also some of the measures that have been put in place to try and deal with false allegations.
Thank you, Karen. Then what I'll do is I'll ask Luanda there to read then the issues on the chart, and after that, then Advocate Kambula will respond on the issues being raised now. Luanda, over to you.
Thanks, Mr. Gregory. I'll just have to look at it to see if there are any questions in that regard. However, there's a quite interesting comment from Karina Coetzee from NPA. She stated that the protection order does not apply until it was served, but does not expire until the return date. A final protection order can only be overturned by a higher court. It never expires. That's, yeah.
Is the only one on the chart, or is it something else on the chart as well, Luanda?
There's a question there from Millicent Chaukene. She's asking if are SAPS members who are assigned to safety monitoring notice been provided with a workshop / or training to avoid the re-victimization. What kind of an approach is the safety monitoring notice been linked to? So that's the question. While you're busy trying to answer that, I'll just keep on looking at other questions.
Sure. So Karina, thank you so much for that input. Yes, that's 100% correct, that the validity of protection orders don't expire because service cannot be done. And then Millicent, to your question, all departments that are included under the Domestic Violence Amendment Act are required to train their members or officials on their specific role within the Domestic Violence Act, its regulations, and the specific or respective directives and instructions. And I know that in SAPS, there is designated domestic violence and or gender-based violence coordinators that are in place, both during sort of office hours, but then also for when that designated person is not there, there are designated members to work with gender-based violence matters, which would include domestic violence. And they are really there to be the point person for anyone coming to report gender-based violence matters. So those specific members, as far as I understand, will be trained quite in depth, either by SAPS National Office or by their development officers at a provincial level. What form that training or workshop will take, I'm not privy to, but there will be training provided. And in terms of your question about what approach, I'm not sure if you're asking, is the safety monitoring notice based on an existing approach that is working elsewhere, or if you are asking how the communication will take place between the designated or assigned member and the complainants. The first part, I'll just answer both. The first part is I'm not 100% sure. It was something that was brought in during the legislative reform process. So I'm not sure if there's any of the legislators on this webinar who could provide insights, or perhaps Advocate Kumbula could. But in terms of the process, that will be defined in the national instructions exactly how the process and frequency will take place of the court order.
Thank you so much, Karen. Over to Advocate Kumbula. Advocate.
Thanks, Gregor. I might not have received the other questions because I was trying and at the corrections here, and the network is so poor. All right, so, but I would just like to say here that I've put just a note here on the chat, to agree and emphasize with the speakers together with Karina that the protection order, it doesn't matter whether it's an interim protection order or the final protection order, it is invalid and unenforceable until it is served upon the respondent. And as Karina said, whether it will be
Okay, Karen, one or two things very quick there.
Okay. What I can say is that on training, that we are going to hold other webinars for SAPS, and I think Luando does have the dates, if Luando can share. And I'm requesting here the members of SAPS that are here, actually everybody who is here, to, if you would like them to have, to join other webinars, just drop your email address so that then we keep you in our database and we invite you. And then intimately what I can share is that this evening I'm meeting then with the top officials of SAPS, and we'll be discussing the issues of training and together with the presidency. So it's a meeting between those three stakeholders. It's going to be at this evening. So I think that right now I do not have an answer as to when, whether they have received the training or not. All right. So I would say that let's suspend the response to that question for now. Thank you.
Okay, Advocate, to you and Karen, there are two issues very quick, which will also be maybe one of the issues that we can look into that as well, that the return of service sometimes becomes a big problem in a number of key issues as well, that maybe we need to have a way that how we can then deal with SAPS and then also deal then with the sheriffs as well. But sometimes that you pick it up that some prefer having the sheriff to do that and become a blame gaming as well. There's just something that we need to have a look, how do we deal with the matter as a matter of urgency when it comes to that as well. That because one of the issues we've picked up now, in terms of some other discussion as well, where we had in the country currently now on the basis of the sheriff and the sub-interim return of service as well, that because we realize that the court gives an order now, returns on what we've done today, it's going down the next morning as well. That end of the day, that what is happening to the person, the aspect as well. That, and the last one also we have to discuss that it's also that relooking into the victim-friendly facilities. Those are up to standard as well at police stations, because it's one of the big issues that we've picked it up. In some stations that you pick it up that the victim-friendly facility then it's in a server room. That to me is unacceptable as well. We'll have to have ways of spacing being done of victim-friendly facilities. And the statement A's as well are very critical on terms of some of these issues as well when it comes to station levels as well on the matter. Without wasting any time, then we've got 5 minutes left. I will then ask then Karen your last word, and then after that, the advocate, then we'll be closing the session as well. Over to you, Karen.
Thank you so much, Gregory. In those last few points that you raised, I think again it just brings back to myself and Mosaic, and looking at the way that we try to work, is we really believe in collaboration. And when we're looking at things like return of service, the problem with return of service, and looking at all these different role players, looking at the sheriff, looking at police, looking at the availability of victim-friendly rooms and trained counselors to be in those victim-friendly rooms to provide psychosocial services. I think I saw a comment there from Tembakile on the comments that says that, we really need to have social service professionals that walk alongside SAPS in providing trauma counseling for complainants. If we look at all of this, legislation can only do so much and provide the scope and the provisions for law to be applied, but the application of this law happens at a very local level. So I think my final words would be around, we need to start looking at a very local district or station level to see how do we start collaborating more effectively and working and coordinating services to make sure that we strengthen the domestic violence prevention and response system. Because while we continue to work in silos and point fingers at each other, I think we're going to be a very long way from realizing the true potential of the Domestic Violence Amendment Act. So that's where I'd like to leave it for today, and invite everyone else back to future webinars as they play out over the next couple of weeks.
Advocate, your final words?
I'm not sure if she might have dropped off, Gregory. I know she said her signal was a little bit bad.
Okay, that's fine. That Karen, I think what we need to do is that I think I need to thank all the members who are present today, from Brigadier Moeng, from Forensic to Brigadier Pule, to all the brigadiers and all the colonels, and Colonel Kunte, Professor Parker, Labam from OSW, and all the other people that have been part of it as well. But we will have to have a session also very soon, Karen, that on the issue of domestic violence and forensics as well. How do we deal with the matter of forensic? Because we have to start looking at the issue of forensic as well, maybe in August, where we can look at the issue of forensics, because one of the key issues that we've picked up that is also can be a hamper to the act as well. That once more, and Captain Machaba and all the guys that we need to say thank you for being part of it. We will then send the list then to all of you today, before end of the day today, so that then give you then the dates and of all the trainings which will be happening this whole month into the SAPS and all the members here. I need to say that thank you guys, and may God bless you and have a wonderful afternoon. Thank you, Karen. Thanks, bye.
Thanks, everyone. Have a great afternoon.